Welcome to the midweek edition of Legal AF, only on the Midas Touch Network with your co-anchors Michael Popok and Karen Friedman-Agnifilo. Here's the topics we have to talk about today. We're left with no choice. One, E. Jean Carroll case has started, and how close is Donald Trump and Alina Habba? How close are they to being found in contempt and dragged out of the courtroom by federal marshals? We'll talk about that and what's happened just in the first 2 days. If you thought the Rudy Giuliani defamation case and his antics were outrageous, wait till you hear what Alina Habba, who's supposed to be the lead trial lawyer, but is apparently learning on the job, and her client, Donald Trump, have done already in front of a jury, no less. Then we're going to go south, as Ben, our colleague, likes to say, and talk about Fani Willis. And I'll ask the only person on our network is a former prosecutor, Karen Friedman-Agnifilo, if she thinks, even if any of that is true, about Fani Willis having some sort of outside of work relationship with somebody on her special counsel team, a team that she spent, I think, a total of $1 million on compared to Jack Smith's $14 million to do a much easier case against Donald Trump in 2 locations. Whether she feels that there's enough smoke there to have the indictment dismissed by anybody. And we'll talk about that. And then we're going to talk about a revisit when Twitter, remember when Twitter was Twitter? When Twitter fought off or tried to fight off, turning over to Jack Smith's team, Donald Trump's Twitter account, all of his direct messaging, all of the way he used his tweets that they then used to prepare their indictment and to try their case. Twitter wanted the ability under the First Amendment to inform Donald Trump and warn him to allow him to intervene in the case, a case, by the way, that Donald Trump to this day has never intervened in. So the question that was up for the entire DC Court of Appeals, back to the DC Court of Appeals, and all the judges there, I think there's about 12 of them, is should Twitter have been able to tip off Donald Trump before they provided his tweets? Or was there some sort of executive privilege or presidential privilege as a former president that he'd be able to assert to stop that production? The DC Court of Appeals has spoken, and it's not favorable to Donald Trump. Surprise, surprise. And then we'll end our podcast on the we'll go back to New York to talk about the original gag order placed on Donald Trump. There's 2 of them. By the New York State Supreme Court Judge Engoron, related to the New York civil fraud case. Donald Trump didn't like the fact that he was gagged. Everybody complained that was the reason on his side why he didn't testify all the times that he should. And now the highest court in New York has spoken, and Judge Engoron, as we expected and suspected, has been affirmed on appeal, as is his gag order. Gag order matters because even though we just had closing arguments, and Karen and I will talk about closing arguments and Donald Trump's jumping up, much to my chagrin and my embarrassment, having told Karen Friedman-Agnifilo, I thought there's no way the judge is going to let him talk. And then all of a sudden the judge was letting him talk. I wouldn't call it a closing argument, but he did allow him to talk. And we'll talk about what do we think the impacts of that are and the tea leaves that we can read based on comments made by Judge Engoron. All that and whatever else happens tonight while we're on the air that we can then report on, one place. Don't touch that dial, Midas Touch, Legal AF. Karen.
How are you?
I'm doing great for many reasons, some of which you know. Things are going great at the Popok household, and I wish everybody a great start to the new year. But we got justice's wheels are turning and grinding, and Donald Trump is caught underneath, even if he realizes it or not, he's caught under the wheels itself and being churned and spit out here. Let's just jump right in with E. Jean Carroll. You and I are both practitioners. I've tried 35 cases, many of them to juries in state and federal court. You've tried who knows how many, hundreds of cases as a prosecutor. And we're watching, to paraphrase Casey Stengel, great baseball great, former manager of the New York Yankees when he took over the Mets in the 60s. They play a game of which I am not familiar. I don't know what Alina Habba is doing as a trial lawyer, and that trial lawyer part's doing a heavy lift. What have you observed in so far, just 1 day and a half or so into a federal trial against Donald Trump for just to determine if E. Jean Carroll, the former publicist for Elle magazine, is going to get $10 million or more because of Donald Trump's, not only his defaming her while he was president, for which he does not have immunity, on the backs of the trial from April and May, in which another jury found that she was sexually assaulted, I'll call it raped, by Donald Trump in that dressing room in New York in a department store, and awarded her damages then. This is for damages that's happened since, including punitive damages. Tell me what you've observed. Dive into it as only you can as you're at ringside for this kind of case.
Well, I haven't tried hundreds of cases, but I have tried a lot. And there are some very, very, very basic trial skills that Alina Habba does not seem to have. This is in addition to the fact that federal court is a much more formal, much more staid, it's just very different than state court. State court is a little bit like the Wild West. It's chaos. The volume is just constant, lots of volume, lots of cases, lots of people, lots of things going on. Federal court is not like that. Federal court is, first of all, it's beautiful, and you feel like you're in a place that's very special, very majestic, and you feel the import of the federal government and all that comes with it when you're on trial or you're in court in federal court. And the judges are much more strict, and everything from in state court, if you're going to go to trial, you answer ready that day. If you're not ready, they'll adjourn it. It's very loosey-goosey. Federal court, if you have a trial date, it's going that day, period, full stop. I mean, it's like the difference between night and day. That's how different state court and federal court are. And I think that Alina Habba is seeing that difference. And so is Donald Trump. He's not going to get away with the stuff that he got away with in Judge Engoron's state court civil trial. The other very big difference is that there's a jury here. It's not a bench trial. And in any jury trial, whether it's state or federal, a judge is going to do everything they can to protect the jury from inadmissible, inappropriate, whether it's comments or evidence or remarks, et cetera. It's very, very different in a jury trial than in a judge trial. So you were just saying how in your intro that Judge Engoron allowed Donald Trump to give part of the summation or speak. Largely that's because it's in state court, but really it's because there's no jury there. So there's no harm, no foul. And so in federal court, you're going to see it very different. And that's exactly what's happening in that civil trial in front of a jury, in front of Judge Kaplan, who is a very respected judge here in New York. And Judge Lewis Kaplan is making sure that nothing inappropriate or inadmissible or in any way could taint the jury pool comes into evidence. So you have that going on with between Alina Habba and the judge, right? You've got him here saying, Ms. Habba, we're going to do it my way in this courtroom, and that's how it's going to be. You tell me the line number, and I'll read it, and we'll go from there. And then Judge Kaplan has to take a recess because she doesn't know what she's doing. And Judge Kaplan again schools her. No, we're not going to read out loud a document not yet in evidence. We're going to take a break right here to 3:30, and you're going to refresh your memory on about how to get a document into evidence. I mean, if a judge said that to me, I think I'd have to go out and just cry. I mean, I can't imagine being accused of not knowing how to get a document into evidence. Trial lawyer 101, there are basic things you need to know. Basic. This is not complicated. You don't even barely have to be a trial lawyer. You know, one of my fun side jobs is I'm the legal advisor on Law and Order, right? So I go there and I tell them what to do and what not to do. Even the actors who play lawyers, right? The prosecutors and the lawyers, they all know what's the most important thing that you do when you go to court and you're talking to a judge. You stand. You do not ever sit and talk to the judge. You stand if you have something to say. And Judge Kaplan had to school Alina Habba on that absolute basic thing and told her, stand when you speak to this court. It's out of respect, but it's also just how it's done. And she doesn't even know that. Whether it's how to get something into evidence, how to cross-examine someone properly, whether to object and what to object to, not to do speaking objections. And it's this entire cross-examination between her and E. Jean Carroll, or even just objections during the direct examination when E. Jean Carroll's lawyer, Robbie Kaplan, is speaking, is just absolutely shows that Alina Habba has no idea, none, how to try a case or how to be effective in court. And as a result, it's causing this judge to, I think, lose his patience and really, really have to just keep control over the courtroom, because Alina Habba just doesn't have a clue. And then the other thing that's happening, and that we'll get to after you comment on Alina Habba, is Trump and his conduct in court. But why don't you talk about what you think about what's going on with Alina Habba?
Yeah, and I'll jump into the others, and we'll go back and forth a bit. Alina Habba, I could tell from her resume that she doesn't know what she's doing in federal court. I'm not sure she's ever tried a case of consequence in front of a jury. And I'm not being mean. I'm just talking about somebody's resume. And maybe at 15 or 18 years out of law school, the way she is, I'm not sure. No, I had already tried some cases of consequence in federal court by that point. So I was trying to empathize with her for a minute, but I really can't. And if you don't know what you're doing, then you put next to you somebody who does. And Mike Medallo, who's her partner, apparently doesn't know how to practice in federal court either. I knew we were in trouble yesterday when Alina Habba decided to raise again, despite the fact that the judge had issued 2 orders about the fact that he was not going to allow the trial to be delayed or continued, to allow Donald Trump to go off who knows where. You really can't trust him. And I'm sure that went into the decision making, but about a funeral on Thursday for the mother-in-law. So it was already done and dusted. He had already decided it. He even issued a memo. After he'd done a short order, he'd issued a memorandum order, which laid out the reasons why he wasn't going to do it. And he did not expect, nor was it proper procedure or decorum to revisit the issue on day one before jury selection. And he had to remind her, Alina Habba, let me explain something to you. An order is the end of the conversation, not the beginning of the conversation. We don't continue to dialogue over it, because they got a taste. I said this in a hot take. They got a taste, her and Medallo and the other lawyers for Trump, in the Engoron trial for the New York Attorney General. And they got a taste for trying to abuse and being disruptive and not following the rules, not minding their P's and Q's, just not being appropriate practitioners or advocates in a courtroom. And because it was, as you said, it was more tolerated by Engoron because there wasn't a jury president, and frankly, it wasn't federal court. They got used to it, and they got the taste for it. Well, I'm sorry, but there's a huge difference. And I've been in both courts. I pride myself on being able to adapt to whatever environment I'm in: arbitration panel, appellate panel, state court, or federal court, criminal or civil. But a lot of lawyers don't, and they only have one gear, and they grind that gear if they're in the wrong court. And what we're watching is Alina Habba just grinding her gear. I'm not sure she's that skilled in state court, but the federal court stuff is just amazing. I commented on, I was taking some notes about things that she did with Judge Kaplan yesterday, let alone today. She called him sir. I'll tell you, in 32 years of my career, I've never called a judge sir.
No, you call him judge or your honor.
Yeah, I never call him judge either. Your honor. I mean, yeah. It's your honor, and for very good reason. So it started off, that just shows you somebody who's not experienced. Then she didn't, as you said, she didn't get up. You got to get up. You get up for the jury and you get up for the judge when you address the judge. You don't do it from the table unless you've asked permission for that, which of course nobody did there. Then they started raising the issues that had already been decided and or have been waived, which is that Shane Crowley, one of the lead lawyers for Robbie Kaplan that's representing E. Jean Carroll, who did the opening here, and by the way, did the opening in the first trial back in April and May, used to clerk, was a federal law clerk for Lewis Kaplan, and apparently he co-officiated at her wedding. If you had an issue about that, which was public back then.
He disclosed it. They disclosed it.
Right, and they disclosed it. Then that is your opportunity to move to disqualify or ask the judge to recuse himself. Maybe Trump just figured it all out, But if Habba and Medallo just figured it all out, that's another example, another badge of malpractice for those two. I'm not saying that there were grounds to disqualify the judge, but you at least at that moment had a good argument that maybe the judge could not be impartial. At least you could make the record for it. But you can't wait after the first trial is over and the same person is doing the same thing in opening and go, objection, you presided over her wedding. Right. You knew that 4 years ago, just like you knew that Trump was president and you didn't assert presidential immunity. So you got that going on. And then you got Donald Trump, who's decided from day one to act out while he's there. They obviously have gotten their notes together. And the notes are, we're going to continue to put our hand on the stove until we get burnt. And they're going to get burnt quickly with a federal judge. So, for instance, jury selection, where you're supposed to, listen, quiet your mind and quiet your body and don't do anything to disrupt the process, especially if you're the defendant in effectively a rape punitive damage case. And they asked the putative jury, anybody here think that Donald Trump is being unfairly accused or prosecuted or in lawsuits? And a couple of them raised their hand, and Donald Trump, like a 6-year-old, put his hand up. Look, me, I think so, in front of the jury. And the judge says, yeah, well, we know where you stand. All right, next. Like, don't do that. Don't. And all you're going to do, I want to talk about the jury for a minute. All you're going to do when Alina Habba can't figure out how to get a piece of evidence in, when Alina Habba can't figure out how to make an objection, which is literally, we learned that in law school in moot court board, in evidence 101. I still carry around a dog-eared copy of evidentiary foundations so that I can remember and brush up on things. And when the judge turns to you and says, objection, and give it to me in one word, meaning don't give me a speaking argumentative objection in front of this jury. And of course, she can't do it because she doesn't know her objections. She said earlier today, when the question was being asked on direct of E. Jean Carroll, something that sort of touched on a legal issue, but not really. She said, objection. And so, what is it in one word? And the one word, well, it would have been a little bit longer. It would have been calls for a legal conclusion, but she couldn't even get that out. He said, sit down, denied. So she's not winning. And all that does to the jury is indicate that you are an amateur, that you are insulting their intelligence. And if she thinks she's scoring points and the jury's going to fail, I've never seen a jury feel sorry for a lawyer who's drowning at the hands of a judge who's making her follow the rules ever. And so you have that. And then you got Donald Trump, who, I'll turn it over to you, who was huffing and puffing so loud about disdain for E. Jean Carroll's testimony. Another heroine giving authentic testimony where she's in tears, talking about not only the event that happened to her in the dressing room, but having her entire authenticity of what happened to her denied in front of millions of people by Donald Trump, and then having her be attacked on social media. And he's just saying, and he's not even doing a stage whisper. It's not even sotto voce. He's like, well, no, she's got a good memory now. Well, that's totally wrong. That's a lie. It was so loud. Shane Crowley called it out as a lawyer for E. Jean Carroll at a break when the jury went to lunch and said, Judge, you got to talk to Trump because he's talking so loud that not only we can hear him over at the plaintiff's table, but certainly the jury would be influenced by that. And then take it from there about the judge and Trump going head to head, locking horns today. And you know who wins the locked horns of a judge and a defendant? The judge.
Always, yeah. Look, I mean, he was saying things like this is a con job, even after Judge Kaplan told him to keep his voice down. And Judge Kaplan, though, what he said, what I thought was brilliant was he said, look, you can be excluded and forfeit your right to be at this trial if you are disruptive. He said, I hope I don't have to consider excluding you from the trial. I understand you're very eager for me to do that because you just can't control yourself. And Trump obviously called him a nasty guy after he told Habba to sit down because she had said, I don't like being spoken to like that. And so he keeps saying all these things about the judge, about E. Jean Carroll, about the process, and he just can't control himself, and it's pissing the judge off. I just want to tell a little story because it reminded me of, and I've told this story before, but it reminded me of this when the judge said that he could be excluded and forfeit his right if he's disruptive. And for people who wonder, can you do that? Doesn't a defendant have a right to be there? Absolutely, can a judge do that? and they can do it in civil cases, they can do it in criminal cases where there's even more at stake, right? It's not just money, it's about your liberty. A defendant doesn't have a right to be present and disrupt the trial, disrupt the jury. I mean, you get warned, but you can be taken out. And the story I want to tell, and I've told it before, is it's my Jack Smith story, right? How Jack Smith and I started in the office together in the early 90s. I think I started a couple years before he did, but we were very young prosecutors together. And in the mid 90s, I was pregnant with twins, and it became a little high risk. And so I couldn't try a case that I needed to try. And it was a really serious case where this defendant who had a record in, I think, 8 different states, a felony record all over the country. He was just a walking crime spree. He carjacked a livery cab driver in New York, and then went on a high-speed chase throughout all of New York City, ending in a head-on collision with police officers, causing injuries. And he was just disruptive in court. He injured a police officer in the courtroom, and he just very disruptive. And he was so disruptive that he fired his lawyer and wanted to go pro se. So you had this really just violent predicate criminal who was in court and just constantly being disruptive. And he was speaking, right? Because he was the lawyer. He went pro se, and you're allowed to do that, right? So he got to speak and be disruptive and also claim he was the lawyer. Well, he kept having to be, so anyway, I'm pregnant. I couldn't try the case, but it had to go to trial. And young Jack Smith steps up and was such a good guy and such a nice person that even though he was busy and had his own caseload, he said, I'll do it for you. And he took the case. And it wasn't a high profile case. There was no big fanfare. It was a pain in the butt case because the defendant was so difficult. And there's Jack Smith, who just wanted to be helpful and be nice. And anyway, the reason this story reminds me of that story is because the defendant, Carroll Davis was his name, just went crazy in the courtroom and refused to listen to the judge, refused to control himself. And so the judge excluded him. That means there's no defendant, but no lawyer either. There's nobody cross-examining any of the witnesses. So Jack Smith just put on his whole case, no cross-examination, and that was upheld on appeal because the defendant was so disruptive. So anyway, I just had to tell that story.
No, Trump is on his way to being tried in absentia. We predicted it before on various hot takes and in Legal AF that it was Donald Trump's goal to get excluded, and then you make himself into a martyr again, that he got excluded. He's acting out in social media, walking into the courtroom. It gets brought back into the courtroom in a biofeedback loop by the lawyers for E. Jean Carroll, who then show E. Jean Carroll things that just happened as they're coming in. Habba can't figure out how to bring new evidence in that's not marked, and so she gets chastised. And Trump, the kind of left out the locked horns with the judge. He said, "I know you can't control your." Judge says, "I know you can't control yourself, and you're itching for me to." I'm paraphrasing. You're itching for me to bar you from the courtroom. And Trump said, "You can't control yourself either." I mean, it's literally like watching a 6-year-old who's on trial. In this case, for unfortunately, that 6-year-old raped and defamed a woman. But other than that, his behavior is just so ridiculous. And then we got a big moment today on the Midas Touch Network. Bad segue, sorry. Is that came up in cross-examination for Alina Habba. Here's where I'll credit her for being a very skilled examiner. She decided to bring up to E. Jean Carroll about President Trump and whether they're trying to make the argument that she's not really damaged, that she's gotten celebrity. This is disgusting. She's gotten celebrity out of the fact that she got, I don't know, let me finalize the sentence. She got raped in a dressing room by Donald Trump. I mean, I don't get it. But that she's, to try to reclaim her dignity as a victim, and she's gone on various shows, CNN, but she's gone on Midas Touch on a podcast or two. And Alina Habba, we always thought that they were obsessed on the other side with the Midas Touch Network. And she says, let's talk about the podcasts. And this is Alina Habba, The Daily, all ears, Midas Touch. And you could hear a little cheer go off in the Midas Touch newsroom at that moment. And of course, my comment to our team on the chain was, God damn it, can't at least Alina Habba continue to list shows and get to Legal AF? We know she watches. The problem is we talk about what she should have done after she's already done it. That's why she's annoyed. And I also joked that she should be sending, I think the Southern District of New York and Judge Kaplan should be sending a bill to Alina Habba to try to teach her. It's like I'm watching moot court practice in law school and some sort of continuing legal education thing. This is going to go terrible. Donald Trump may not make it, not because of the funeral, to the end of this trial because of his acting out and his misbehavior. And the federal judge will bar and ban him. He knows Donald Trump knows he's going to lose this case. Let's just put it out on the table. He knows this Manhattan jury, which is a former transit worker, a former school teacher, a banker, a broker, a person who's originally from Spain. This is, a doctor. This is like a college-educated cross-section of Manhattan and Westchester. They are going to stroke a check for E. Jean Carroll for $10 million or more at the end of this trial, which could end as early as Friday. And Donald Trump knows it. So he's going to get his money's worth. Right? He's going to push it right to the point of being found in contempt. And then he can go to New Hampshire and talk about how he can't get I think we have a new social media post from today, just before the show. I can't get a fair trial in New York. They're all after me. And the judge is crazy. And it's always the same. He can never be held responsible for his own conduct. It's always the system's against him. New York's against him, the jury, the judge, the grand jury, the special purpose grand jury, all my former lawyers. We could go on. I could just do a list. Everybody's against me. I didn't do anything wrong. It's just complete and total BS. But I did like the fact that Midas Touch got mentioned, and that's only day 2. And at the rate we're going, if she's completed today with her cross-examination of E. Jean Carroll, there'll be a redirect of E. Jean Carroll because he's ending the court at 4:30 every afternoon. Then tomorrow, the expert, I'm not sure they have many more witnesses, the expert that they're going to use for E. Jean Carroll to put on damages, put on her damage model in front of the jury. And then the case turns to Donald Trump. And he's only got, because he doesn't have an expert, because Alina Habba screwed that up as well, about damages or anything else. And he's left with, he wants to put on Carroll Martin, who was a beloved newscaster here in New York on CBS, because she's the outcry witness that Alina Habba, that E. Jean Carroll spoke to the night of the sexual assault and rape.
Yeah, why would he want to call her?
Because Carroll Martin also made a comment, and she's right, that E. Jean Carroll going out in public and talking about these things is not a good thing, and that she should keep a lower profile. She meant that. I've seen the transcript of the deposition. She meant that because she didn't want her to be attacked and abused by Donald Trump. It didn't that happen. As they're going to try to spin it that she was saying that, oh, look at this publicity hound that's E. Jean Carroll out to make this, her 15 minutes of fame. So Carroll Martin will testify, maybe, and then Donald Trump will testify, maybe, and then this will go to the jury. Could go to the jury on Friday. But let's talk about what you think the jury's response is going to be to that. We'll move on to our next topic. But first, got a nice set of sponsors for 2024 here on the Midas Touch Network and on Legal AF, and here's one of them coming up right now.
Support for today's episode comes from OneSkin. If you're still feeling the stress of the holidays like me, you know it can really take its toll on your skin. But OneSkin can help your skin bounce back with science-backed TLC that refreshes and reverses signs of aging from the inside out, something women my age need to be on top of. Their products are powered by scientifically proven peptide called OS1 that targets fine lines and wrinkles right where they start, which is your cells. This isn't just another skincare routine, it's real science breakthrough. In fact, OS1 is the first of its kind to actually turn back the clock instead of just masking the signs of aging. With their full line of face, eye, and body and sun and travel size products, here they are. I actually love them. And people always say to me, I can't believe you are 57 years old. And it's mostly because of my skin and I take care of it. And this is a really fantastic product. It doesn't just promise healthier skin, they prove it. And I am all in. I love using OneSkin as part of my nighttime routine before bed. I'm absolutely thrilled with the results. My skin not only looks more refreshed and healthy, it feels soft too. Just cleanse and apply twice daily. OneSkin, you can put it on your face, your eyes, your body, and there's also a shield that can be used with other products to help with sunscreen. So it easily fits into your current skincare routine. And for a limited time, our listeners will get an exclusive 15% off OneSkin products using the code LEGALAF when you check out at oneskin.co. That's not com, it's .co. Start 2024 off right and give your skin the scientifically proven love it deserves with OneSkin. OneSkin is the world's first skin longevity company. By focusing on the cellular aspects of aging, OneSkin keeps your skin looking and acting younger for longer. Get started today with 15% off using code LEGALAF at oneskin.co. That's 15% off oneskin.co with legal AF as your code. After you purchase, they'll ask you where you heard about them. Please support our show and tell them we sent you. This is a great time to have healthy, beautiful skin.
Are you self-conscious about your smile due to stains? Are your teeth aging you? Popular food and drinks are known to stain teeth. Beverages like coffee and wine stain them over time. So what can you do to brighten your smile? Well, you should give Smile Actives a try. Smile Actives is safe, effective, easy to use, and will keep you smiling proudly. As you probably know because of all the videos we do, I'm a big coffee drinker, and over time I noticed my teeth lost some of their brightness that I was used to seeing. 97% of Smile Actives users in a clinical trial reported up to 6 shades whiter on average, all within 30 days. Simply add Smile Actives Pro Whitening Gel to your regular toothpaste. It's been formulated with PolyClean technology to boost stain removal and deliver active whitening ingredients into teeth's grooves and crannies to get better whitening. Smile Actives makes a teeth whitening gel that can simply be added to your toothpaste every time you brush your teeth. So no change in your routine, no extra time, and no more messy strips, trays, or lights. People will start commenting on your whiter, brighter smile in just days. Smile Actives is the whitening boost your favorite toothpaste needs to give you the smile you deserve. Visit smileactives.com/legalaf today to receive a special buy one, get one free offer with auto delivery plus free shipping and handling. That's smileactives.com/legalaf. Terms and conditions apply. See site for details. All right, we're back. What do you think the jury's going to do?
I think it's just a matter of how much, right? Obviously, this is a damages claim, and it's a matter of how much punitive damages that they're going to award. Because don't forget, there's 2 types of damages, right? There's the actual compensatory damages that are suffered as a result of this particular defamation, right? Because she's already been ruled or compensated for the sexual assault in the prior trial and the defamations in the prior trial. This is a case where the defamation has already been found by a jury, so it's the law of the case, and collateral estoppel does not allow that issue to be retried. It's just a matter of how much are the damages. And so that's what they're establishing. And the compensatory damages, I think that is going to be just not very much, because like I said, she's already been that's already been factored in the first trial. But the punitive damages, given how much he continues his behavior and he continues to defame her and continues to deny it, and what it's doing to her life. And she testified today about what it's doing to her life. She said, I used to be known as a journalist, and now people think I'm a whack job and that I'm a liar. And this is coming from the White House, from the President of the United States. Because don't forget, this trial, these comments happened while he was president. And we heard from Ruby Freeman and Shay Moss about what it felt like and what happened to their lives when the most powerful person in the country makes accusations about you that are completely frivolous and lies, which is what Donald Trump did against them. And what E. Jean Carroll says and how it's impacted her life sounds very, very familiar. And I think the fact that he keeps doing it, keeps repeating it, shows no remorse. I think the jury will punish him. And I think that the Rudy Giuliani defamation case that Shay Moss and Ruby Freeman won against him shows what was that, $148 million, shows how much punitive damages can actually be. And I think that we are going to see a number that is much higher than the $5 million E. Jean Carroll got in her first trial, that involved the sexual assault and the number
that Robbie Kaplan's put out there is 10 million, but I'm not sure that includes punitives. And then the last comment before we move on to the next topic is injunctive relief, which is an order that comes out of the court, not the jury, to stop Donald Trump from continuing to defame her. You think Kaplan, following the jury's completion of their fact-finding, when asked, do you think he will enter a permanent injunction against Donald Trump under penalty of contempt and criminal contempt if he violates it, if he leaves this courtroom after another jury has ruled that he's now been hit with punitive sanctions twice at maybe the numbers that you're talking about? Do you think the judge enters that kind of order? And do you think this is the kind of judge that would find him ultimately in criminal contempt if he violated it?
Well, so yes and maybe. So 100% yes, that this judge will do that. Will this judge hold him in criminal contempt if he violates it, meaning put him in jail potentially? That I don't know. No judge has been willing to do that so far. And Donald Trump has really, I think, been treated very differently from anybody else in the justice system. And all judges, every one of them, federal and state, without fail, has, I think, shown that they're not willing to hold him to account. I don't know why. I don't know why everybody is so afraid to treat him the way everybody else gets treated, but he is being treated differently. And as a result, I think he takes advantage of them, and he makes not just a mockery of the system, but he really, really just emphasizes the more, because the more they tell him to stop doing something, the more he does it. And then they don't do anything about it. And so it just emboldens and empowers him. And so will Judge Kaplan find him in criminal contempt if he continues to violate it? I sure hope so. I think he would. I think he's a very, very respected by the book judge. I don't think he's the kind of judge that would be afraid to do what is required. But knowing Donald Trump, he'd somehow skate really close to the line and figure out a way to make it so that he doesn't get put in. But that's what I think.
Yeah, I agree with you. I think he'll impose it, and then we'll have to see what happens next. But let's do a follow-up story about, because Fani Willis herself has defended herself. Let me try that again. Fani Willis has defended herself as only she can, eloquently, with passion, at the Martin Luther King Jr. Day at the Big Bethel AME Church in Atlanta on Sunday before Martin Luther King Day. At the same time that MAGA right-wing crazies are attacking Martin Luther King Jr. and defaming his name, she took to the pulpit, literally, and defended her hiring of Nathan Wade, that he's well credentialed, that she hired 3 total special prosecutors. 2 were white. Nobody had a problem with them. 1 was Nathan Wade. She didn't deny nor address whether she was having a relationship with him outside the office, but commented that at least the 2 other special prosecutors, she considered them to be close friends as well. And that, let's be frank, she has a sprawling prosecution and indictment, 17 or 18 defendants to start, 30, 40 counts, a trial that could go on a year. Do people think the Fulton County District Attorney by themselves, without an additional budget, was going to be able to handle that? So the fact that she hired just 3 and maybe total over $1 million in total she should be commended for that. I mean, Jack Smith, God love him, but he spent $14 million in the last year, some of which was for personal security for his team and him because of Donald Trump. But, she's doing it on a shoestring budget. And what she does inside or outside of the courtroom, she said it the way that, her version, or her authentic version, is that they're attacking Nathan Wade because he's a black man that they're claiming isn't credentialed. And the white woman lawyer that filed the motion against Fani Willis and Nathan Wade to have the case disqualified and have the case dismissed and have her disqualified said, well, we're just saying his credentials. He's not really, what has he ever done? And Fani Willis reminded everybody in that church, this Nathan Wade's been a judge, criminal defense lawyer. He's been a assistant attorney general. He's been hired as a special counsel throughout the state, including by white Republicans, to handle matters for them, a well-known quantity. And the fact that he's never tried a RICO case against a former president should not be held against him. Nobody has. We've never had a former president like Trump. And therefore, no one's going to have that credential on their resume. I thought it was an eloquent defense. And I want to ask you from a prosecutor standpoint, when Judge McAfee finally gets around to hearing this issue, if it is an issue, about her relationship with Nathan Wade, and maybe they went away on a cruise together. Who cares? Do you think that's going to get an indictment that came out of a grand jury off of the back of a special purpose grand jury dismissed?
No, the law, this is an HR problem. It's not a problem for, for dismissal or anything like that. I mean, this is just so atrocious what's happening to Fani Willis, in my opinion. And I'm not surprised, though. I've seen this before. Again, when I was working with Cy Vance, Cy Vance was elected in 2010. And that's right around the time that the progressive prosecutor movement began. I don't know exactly when it began, but that's around the time that it was starting. And you started seeing a lot of the conservative, white male, old guard, traditional law enforcement people being replaced by women of color, men of color, although Cy Vance is not. He's a white male, but he was very much somebody who was one of the leaders of the progressive prosecution movement. And frankly, one of the things we did was we created this thing called the Institute for Innovations in Prosecution. And progressive prosecutors from around the country, we all would get together and we would discuss issues and learn from each other and figure out ways we can do things like change the racial disparity issue in the criminal justice system. At these gatherings was very much how prosecutors who are women of color in particular are treated differently and with a double standard than white male prosecutors who are also progressive. So, for example, you had Cy Vance, and you also had Larry Krasner in Philadelphia, who I think is very much lauded as a progressive prosecutor, another white man. But women, in particular, women of color prosecutors, without fail, have been run out of town. You have former DA Marilyn Mosby from Baltimore, who I think is under indictment for something she did while she was prosecutor. But make no mistake, she was run out of town, right? You got DA Kim Gardner in Missouri, also run out of town. Soon to be former state attorney Kim Fox in Chicago, same thing. Former state attorney Aramis Ayala in Florida, et cetera. And you've just got this completely different standard that women of color are, and I know Fani Willis was talking about Nathan Wade and saying how when will a black man ever be considered qualified for the job? No matter what his resume is, he'll never be qualified enough. Of course, they don't scrutinize the white people, as you said. She focused on that. But what struck me about this whole hatchet job is look what happened to Claudine Gay at Harvard, right? Did I like what she said about when she was asked about the Hamas and all that whole thing? No, it was not a good answer. She apologized later. And next thing you know, because she omitted certain quotation marks and didn't cite things properly, she's being accused of plagiarism. And she was run out of town by the billionaire, what's his name? Bill Ackman, the billionaire man whose own wife, who's a woman who is a very well-respected MIT academic, has also been accused of plagiarism. Do you see anything? And again, it's like people who just don't cite things perfectly, but she was run out of town. And that's what happens and has been happening. And that's what I think needs to be called out here.
Yeah, Fani did it. I mean, I watched the hour that she gave her speech at the church, and she defended herself in a very great way. She said, why is my judgment being questioned for hiring the exact same person that a white Republican sheriff hired to do a special investigation? And look, Nathan Wade is not a perfect human being. Who among us is? I mean, is he in a divorce proceeding? Yes. And did he get found in contempt apparently in that divorce proceeding because he didn't provide all the financial records he should have to his ex-wife or soon-to-be ex-wife? It looks like he did. But does that mean he's not doing a day's work for a day's pay and getting paid for it, the $650,000 to try this case or to be the lead sort of special prosecutor related to it? No. And I think I want to tamp down any kind of argument that could come up with our audience by other people that therefore this indictment should be dismissed. This indictment is not going to be dismissed by Scott McAfee. It would totally undermine the fact that it's Fani Willis didn't indict Donald Trump. A special purpose grand jury, after 7 months of listening to evidence and witnesses, including Rudy Giuliani and Lindsey Graham and everybody else, recommended the indictment of Donald Trump along with about 18 others. And then she didn't even do that. She didn't indict because she's not allowed to do it exactly that way. She then convened 3 or 4 months later a indicting grand jury, and the grand jury indicted Donald Trump. And the argument that she's keeping the case alive, even though it's in bad faith and she should have used her prosecutorial discretion to drop the suit, drop the charges, is because she's trying to line the pocket of her boyfriend so they can go away on a trip. I mean, it's just, it's so ridiculous and insulting, misogynistic, and ultimately, I'm sorry, I'll call it out for what it is, racist. I agree with you. I think if she was a white man, we wouldn't be having this dialogue. But the good news is none of it's going to work. I think it'll strengthen her hand ultimately with Scott McAfee, the judge. And I think when he gets around to holding the hearing and she gets to defend herself, not on the pulpit of the church, but in the courtroom itself, I think the judge is, listen, is he, like you said, is he going to be like, really, of all the people you had to date Nathan Wade? But that's an HR issue. That's not an indictment's veracity, validity basis issue to get it dismissed. So if these people like Mike Roman and Donald Trump and the rest, Giuliani, jumping on this bandwagon, they go, oh, here's our chance to bury Fani Willis once and for all. It won't be. It won't be. Your indictment continues.
So a couple of things. Number one, the allegations are that they had an illicit affair. Well, first of all, Fani Willis is single, and so is Mr. Wade. And number one. Number two, they're on the same side. If the prosecutor and a defense attorney were having an affair, or a prosecutor and the judge, or the defense attorney and the judge, any of those scenarios would be a conflict and could be grounds for some kind of pretty harsh remedy, actually. But they're on the same side, right? So there's no conflict there, number one. Number two, he's being paid $250 an hour. At least that's what it appears the records are. That some people would call that, as a lawyer in private practice comes out, they would call that low bono, right? Like, it's not pro bono, but $250 an hour is not a lot of money, and it's what everybody's being paid, and it's for work that he's actually performed. So it makes no sense. I actually don't think there should be a hearing, because I don't know what the scandal is. What are they going to do a hearing about? What is the impropriety that they would have a hearing about? So I actually disagree that there should be a hearing, number one. But my one concern, I agree with you, the case will not be dismissed. But if for some reason the judge finds an impropriety in some way, what he could do is he could remove either Mr. Wade or even Fani Willis from the case and appoint a different prosecutor. And that would be a shame, because Fani Willis, she's an excellent lawyer and she's an expert in RICO. She knows what she's doing. And again, I'm not really sure what if raping women, if engaging in persistent fraud, if bragging about grabbing women's private parts, about trying to steal an election, right? If all of these things that Donald Trump has done, and that's only a couple of things, if that doesn't disqualify you from being president, how can having a consensual relationship, if it's true, but I'm assuming it's true because she hasn't denied it, how is that an issue, right? I just don't understand what the issue is. And I think the whole thing, people should be offended by it, should be offended that this is even coming up. This is a personal or personnel matter at its worst. Stop holding her and others to a different standard than we hold everybody else.
Agreed. We're going to talk about, we'll continue to follow it. I mean, Scott McAfee will hold a hearing because there's a motion. He's not going to just strike the motion, but I think he'll make short work of it. Fani Willis will be fine. He certainly won't fire Fani Willis and keep Nathan Wade. I mean, either both go or neither of them go. And I agree with you. I don't see grounds to have either of them replaced or even chastised related to this. We're going to talk about another loss for Donald Trump at the D.C. Court of Appeals level. You need a scorecard to keep track of them all. This one having to do with the Twitter account information that was provided by way of a subpoena that was issued to Twitter, or came out of the grand jury to Twitter, about Donald Trump. Donald Trump not having intervened in that case at all, but Twitter, led then, or newly led by Elon Musk, was asserting the First Amendment and saying they wanted to be able to warn Donald Trump and let him know that his tweet and his DMs and everything were going to be turned over to the special counsel. Well, we'll talk about what the en banc full bench of the D.C. Court of Appeals did in relation to that, and then we'll end the show today and talk about the New York Attorney General case, the closing argument, whatever you want to call that, the Donald Trump standing up for 2 minutes and doing his version of Seinfeld's Festivus, his airing of grievances and then sitting back down. And then another loss for Donald Trump this week at the highest level of the New York state system in terms of the gag order, and the gag order being affirmed. But we'll do all of that and wrap the show up. But first, another word from one of our great pro-democracy sponsors. Keep your New Year's resolution going with Factor. Factor's ready-to-eat meal delivery takes the stress out of meal planning and sets you up for success. Skip the grocery stores, prep work, and cooking fatigue. Instead, get chef-crafted, dietitian-approved meals delivered right to your door. With over 35 meals to choose from per week, including options like keto, calorie smart, vegan and veggie, and more. Forget frantic lunch preps and rush dinners. Factor's 2-minute meals are your secret weapon in the new year. Fuel up fast with restaurant-quality meals all delivered right to your door. Factor now offers loads of snack options like breakfast smoothies, juices, snacks, and more to keep me going no matter what's on the schedule. Skip the overpriced takeout trap. Factor is cheaper and way more delicious than takeout. Their meals are ready to heat and eat in just 2 minutes, which means more time for you. Need a special occasion meal? Gourmet Plus is the perfect solution if you're looking for fast, upscale options done easily. When things get hectic, Factor is flexible. Change your order up every week with plans from 4 to 18 meals per week, or pause or reschedule your deliveries anytime. Factor's no prep, no mess meals, free up time otherwise spent shopping, cooking, and cleanup. No more wasting time in the kitchen. Not only does Factor offer fast, simple solutions when I'm too busy to cook, they also help me stay on top of my goals. With offerings like Protein Plus and Keto, I can stay on track. This is definitely going to come in handy for my New Year's goals. In addition to ready-to-eat meals, they have cold-pressed juices, smoothies, Energy Bites extra protein veggie slides, and more to keep me energized during frantic times. Head to factormeals.com/legalaf50 and use code legalaf50 to get 50% off. That's code legalaf50 at factormeals.com/legalaf50 to get 50% off. When I started podcasting, an online store was the furthest thing from my mind. Now I'm selling our Legal AF mugs and Legal AF t-shirts, and it's easy. So easy. All because I use Shopify. Shopify is the global commerce platform that helps you sell at every stage of your business. From the launch your online shop stage to the first real life store stage, all the way to the did we just hit 1 million orders stage? Shopify's there to help you grow. Whether you're selling scented soap or offering outdoor outfits, Shopify helps you sell everywhere. From their all-in-one e-commerce platform to their in-person POS system. Wherever and whatever you're selling, Shopify's got you covered. Shopify helps you turn browsers into buyers with the internet's best converting checkout, 36% better on average compared to other leading commerce platforms, and sell more with less effort thanks to Shopify Magic, your AI-powered all-star. We use Shopify at store.midastouch.com, and it has completely revolutionized our business. It allows us to easily manage our shop, view analytics, provide the best customer service, and streamline our entire online shopping experience from A to Z. We wouldn't be able to bring you all the products you know and love without Shopify, and we can't speak highly enough about it. Shopify powers 10% of all e-commerce in the US, and Shopify is the global force behind all birds, Rothy's, and Brooklinen, and millions of other entrepreneurs of every size across 175 countries. Plus, Shopify's award-winning help is there to support your success every step of the way. Because businesses that grow with Shopify. Sign up for a $1 per month trial period at shopify.com/legalaf, all lowercase. Go to shopify.com/legalaf now to grow your business no matter what stage you're in. Shopify.com/legalaf. All right, we're back. Let's talk about Twitter, back when it was called Twitter. So I'll frame it, and then you and I can bounce it around. So Jack Smith, properly for a defendant, a criminal defendant, is known to use social media as a sword and a shield, as a way to interfere with the democratic process and the peaceful transfer of power. Of course, Jack Smith wanted to get his hands on Donald Trump's tweets, not just all the ones that existed, but maybe ones that were in draft, maybe his direct messages, and be able to have the full library of all of Donald Trump's social media for the time period that matters in the indictment. What's a better place to go for that than to have the grand jury issue a subpoena to Twitter? Now, the judge also approved, I guess it was the magistrate judge, also approved a order directed at Twitter in requiring them not to inform the account holder, i.e. Donald Trump, about that the turnover of those documents, for obvious reasons. And there are a series of reasons why you do that, including the possibility of destruction and other things that go to spoliation of evidence and that type of thing. And Twitter didn't like that because they wanted to bend over backwards and help Donald Trump. And so they wanted to be able to, first they didn't comply with the subpoena and wouldn't turn over the documents, requiring a motion to compel and an award of attorney's fees and a sanction by Judge Beryl Howell, who then was the chief judge of the DC court system and presided over all things grand jury, the secret grand jury process. And so she had a full evidentiary hearing. We covered it here on the Midas Touch Network and on Legal AF. And she heard from the lawyers for Donald Trump. For Twitter, why do you think you shouldn't be sanctioned? You didn't comply. You didn't turn over the documents. You're late. And what about this other part about the First Amendment? And you want to be able to tell Donald Trump against my orders that he not be told. We hear argument on that. When she was done, she sanctioned them, I don't know, $300,000 or $400,000. They didn't like it. They took it up to the Ninth Circuit and the DC Court of Appeals, which is the appellate court for this. And the 3-judge panel said, yeah, no, you lose. The judge was right, Beryl Howell, as she often is, and the sanctions were appropriate. And no, you didn't have any right to let Donald Trump know about it. And so they didn't like that. And so they took an en banc. They asked for en banc review of the order. In order to get en banc, you got to get at least the majority of the judges that sit, I think there's 12 in the DC Court of Appeals, to agree that it's an interesting issue that should be decided by all 12 of them and not just the 3-judge panel that normally makes precedent in any particular Court of Appeals. So they got there, whatever it was, seven people thought it was interesting. And so they held an en banc. So you go in there, just rows and rows of judges, and you brief to them and you argue to them, and majority wins. So you just got to win by one in that. It doesn't matter. And there was, why don't you take it from there? And I think you did you maybe even a hot take on it, and go over those that were on the other side, on the Donald Trump side, and those that were on the side of the Jack Smith, and what happened in the en banc decision.
This was a really interesting one, because this really fell down partisan lines, right? The 4 conservative judges, 3 of them are Trump appointees, voted and issued a statement, if you will, or almost like a dissent, with this opinion, because the opinion itself was very, very short. I think it just said denied or petition denied, something very, very short, and that's it. The majority, the ruling, the decision. But Judge Naomi Rao issued a statement. It was joined by Judge Henderson, who was the judge who listened to the presidential immunity claim was on that 3-judge panel about a week ago. Judge Katsas and Judge Walker, all Trump or Bush appointees. And what they basically said in this quite kind of a long statement, I think it was maybe a dozen pages long or so, that basically they didn't like the fact that there was this non-disclosure order, right? Where Jack Smith could have gone to the National Archives and asked them for the president's phone, or the tweets, I should say, the drafts, et cetera, because that was all turned over to the National Archives according to the Presidential Records Act. But Jack Smith decided not to do that, and instead to go straight to Twitter to get this information, because the National Archives under the Presidential Records Act then would trigger a notification to Trump, who would then be able to determine whether or not he wants to assert any privileges, et cetera. So A, not only would it slow things down, B, it would make it so that he'd be notified. And just so people understand how prosecutors work, it is absolutely standard course when you have an investigation pending that you don't want the target of the investigation necessarily to be notified about it, because they could destroy evidence, hide evidence, change evidence, et cetera. And so you want that information to just come to you. And so it is absolutely something that all prosecutors have done. If you are subpoenaing, especially social media information, you don't want them to know that there is an investigation necessarily, and for that reason. And so Jack Smith went to the court and asked them for this non-disclosure for that reason, and he's very open about that. But this dissent, if you will, they didn't like that. And they basically said it deprived Trump the opportunity to intervene if he wanted to. But, the thing is, what I didn't like about it, and what I thought was sort of strange, and why I very much disagree with this conservative dissent, is because there could be any number of privileges that you could assert based on information that you get from anywhere, whether it's an email, whether you get a search warrant for email, or whether you get Facebook or Twitter or any of the places that social media that you could get. And prosecutors' offices, especially Jack Smith, they're going to get stuff that might have marital privilege information, or, who knows, maybe he was communicating with Melania, or it could have attorney-client privilege. Maybe he was communicating with one of his lawyers. So executive privilege isn't the only privilege that could be in any of these communications. And any sophisticated prosecutor, Jack Smith is one of them, will have what's called a taint team. And so what they will do is they will give the information to this taint team, who's a completely separate team from the prosecution team. And there will be a wall, an absolute wall, and no communication. And if there's any communication that is found to be privileged, it gets walled off and the prosecutor will never see it. And so I just didn't understand why the Twitter communications, why executive privilege was somehow would make it so that prosecutors have to do things totally different than they do all across the country in every criminal case where you want information subpoenaed that could have privileged information. But they were very, very much saying that this is very different here, and that they should have gone the route of the National Archives and done it that way, because that's what they said was Congress was very clear and very careful in providing a procedure for obtaining presidential records, and that should have been followed. But this isn't just obtaining presidential records for historical purposes, or because necessarily you want, who knows why people go back and why a president would want a prior president's presidential records. That's what the National Archives and the Presidential Records Act is about, right? It's not about when there's probable cause that a crime occurred and that evidence could be destroyed, because that's what the judge found, right? That's what you'll find for the non-disclosure. The judge will have to find that there's a reasonable likelihood that the evidence will either be destroyed or secreted or somehow spoliated, or whatever the the verb for that would be. And so it's very different than just a trip down memory lane or what other reason you would seek to obtain records from the National Archives. So, they go on and on in this statement about the independence of, the separation of powers and Nixon versus United States versus Nixon and citing law that they say has made this case to be a significant departure from historical practice without having to do the things that you need to do in order to justify it. What worries me, however, is this 4-judge dissent just gave a roadmap for the Supreme Court, if they want to, on how to rule against Jack Smith. Now, what happens if this evidence turns out he wasn't allowed to do it this way? I think at worst the evidence gets suppressed. So we don't know what's in these DMs, or whatever the Twitter communications called, because that's the only thing that would be potentially executive privilege here, because tweets are public, right? So they're not privileged, they're announced to the world. But I guess things that are communications between Trump and others while he was president would be the only thing that is in there.
Or unsent tweets.
Or unsent tweets. So so the content of that is, I think, what we're concerned about here, and we don't know what it is because Jack Smith hasn't said it, but I think at worst they just get suppressed.
Yeah, we'll continue to follow it. I'm not that concerned about it. The entire case does not hang on his tweets.
Exactly.
They were mentioned in the indictment in passing, but it's another example of Jack Smith doing really amazing work to leave no stone unturned in locating potentially probative evidence against Donald Trump. And these are things that have his fingerprints on it because Donald Trump either authorized it or tapped it out himself. And it's a great way to hang the person with their own words in front of a jury. Speaking of trying to hang yourself with your own words, let's move finally to the New York Attorney General conclusion of the $450 million or so New York civil fraud case. We had closing arguments. The 11-week trial ended. There was a one month gap where the case went dark on purpose while we went through the holidays, and Judge Engoron let people collect themselves. And then we talked about last week how at the last minute, Chris Kise, on behalf of Donald Trump, dropped the bombshell in an email that they were thinking about having Donald Trump stand up and say something in some sort of closing argument. And the judge went back and forth. We talked about it. And the judge said, take it or leave it. If he wants to give his closing, I'm going to have these parameters. And Chris Kise didn't take it. And I said, I don't think we're going to hear a closing argument by Donald Trump. I don't know what happened that day, but when Chris Kise tried it again and said, because he and Alina Habba, who did it just as terribly in doing her closing argument section, she didn't do the whole thing, in front of Judge Engoron as she's doing in federal court trying to try a case in front of a jury. Same person, same lack of skill set. And I guess she was there to attack Letitia James, the New York Attorney General, and her choice of coffee cups, and whether she took off her shoes to rub her feet at one point. I don't know. The whole thing was so bizarre. Usually when Alina Habba starts to talk, I flatline, and somebody has to wake me up because I know I have to do analysis for a show like this. But Chris Kise was the leader of the closing, and then my client wants to speak, and then judge said, all right, you want to stand up and say a couple of things, and he stood up and he did a 2 minutes of attacking the judge and saying it's unfair and I'm not guilty and nobody was misled and there's no victims and whatever. And then he became uncontrollable. The judge told him to sit down. And Mr. Kise, control your client. And he sat down. The whole thing sort of ended as quickly as it had begun. It's not going. Let me give my view, and then I'll turn it over to my esteemed colleague here. This is not going to change the mind of a judge who sat through a year of trial work in this case, dozens of hearings, had issued a temporary injunction to put a monitor over all of Donald Trump's assets and business operation based on his finding of persistent fraud. The same judge that found on summary judgment, after reading all of the briefings and all of the undisputed facts, found fraud already against Donald Trump, made his observations about the credibility of witnesses, including expert witnesses, sat through 40 witnesses, sat through thousands and thousands of, or is going to read thousands and thousands of exhibits. Donald Trump standing up and saying, and throwing his food from his high chair at the judge for a couple of minutes is not going to change this judge's mind in favor of Donald Trump at all. And the judge said, I'm going to get my order out by the end of January. I thought it would come right in the middle of the E. Jean Carroll, jury selection process. But what did you make? This is our final segment, Karen. What did you make of the closings and Donald Trump and then Judge Engoron? And where do you think Judge Engoron lands the plane once he's done as the sole trier of fact in the case?
Yeah. So you and I discussed, I think it was at last week's Legal AF, where you were saying that because Trump wouldn't agree to these conditions, that's it, and Judge Engoron's not going to allow him to speak. And I think I said I think he will tomorrow. And the reason I said that is similar, just to bring everything full circle. Things in state court, especially in New York, or at least in where I'm used to practicing, which is in New York City, they're just much more loose or more forgiving than federal court. And it's a bench trial. So what's the harm, right? So I thought he'll let him do it, because give him some leeway and don't give him another argument that he can make on appeal where he is saying it's unfair and no one will let me do anything. So, I mean, look, no good deed goes unpunished, because you give him an inch, he takes a mile, and he takes advantage of you, which is what Donald Trump always does and did. But I see no harm there. And so I wasn't surprised that Judge Engoron did that, even on the heels of being swatted at his house that morning, at his personal home, which is just outrageous. But look, similar to or consistent with this being less formal, the closing argument was much more like an appellate argument, in that there was a dialogue between the judge and the lawyers on both sides, right? He had conversations where a lawyer would make an argument and the Judge Engoron would interrupt and say, yes, but what about this? What about that? Address this. That doesn't happen normally in summations. Summations, if there was a jury there, I should say, normally, if there's a jury there, a judge would do nothing but call balls and strikes during a summation. And most lawyers try not to interrupt each other's summations. And unless you have a really strong objection, you let them speak. And that's just sort of how it's done. But the judge certainly would not interrupt and say, well, what about this? What about that? At most, they would admonish you if you venture into an area that's inappropriate. They'll say, don't talk about the law. That's what I'll do. That's my job. Make your arguments about the facts, or things like that. But they're not going to ask questions or give opinions on how they think it's going. But he did that very much. It was very much a dialogue during these summations. And one of the things Judge Engoron said to the prosecutor, or to the attorney, the assistant attorney general, who was giving their summation, was saying, "Where's the intent for the kids? Right? I just don't see it." And if you remember, there's 6 or 7 charges here, right? Charge number 1 was already found to be Trump and everybody found to have engaged in persistent fraud in their businesses. But the remaining counts require an intentionality and a materiality. And so it's like persistent fraud plus, right? And that's where the plus part is where Judge Engoron signaled he doesn't see it against the kids. And we've been saying all along, and I've been saying a lot in many different episodes, that Judge Engoron is not going to find all of the charges against all of the defendants. I thought he was going to potentially not find Trump Sr., Donald Trump, defendant Trump, former President Trump, liable for all of them, that he's going to hold back on one or two. I think now it's more likely, or in addition to that, he's also not going to find that the kids are liable for certain or for many of the remaining charges. And I think that's how he's going to ultimately rule. And it's a smart thing for him to do as the judge, because Trump's biggest complaint, and the thing that he and his lawyers have made the record for, is that the judge is biased, the judge isn't listening, the judge has made up his mind already, that he's not keeping an open mind. And as the finder of fact, because there's no jury here, it's important he has to do that. And so by not giving the prosecution everything they want, and by saying they didn't meet their burden on either certain charges or certain defendants, he protects his record in that way. And I think the appellate courts will say, look, he clearly was doing that, because he clearly was listening and didn't have his mind made up, because he found, based on the evidence that came in, that certain elements weren't met against certain defendants. So I think it would be a smart thing to do. I think based on his comments, that's what he will do. And we'll see that soon, I guess.
Yeah, I think by the end of, I agree with you. I think by the end of January, we're going to get the ruling. I think he's going to pick and choose between the counts, but the foundational counts that will lead him to take a lot of money out of Donald Trump's treasury and pocketbook and put Donald Trump out of business for a long, long time, I think is we're just counting down the days that happens. And then there's an appellate process. It's a state appellate process. Doesn't go up to the Fed, so nobody has to worry about the United States Supreme Court. But you got one place to follow it here on Legal AF and on the Midas Touch Network. We're following the E. Jean Carroll case because Donald Trump's on trial minute by minute with hot takes by the leaders of Legal AF. And then everything else that's happening in Georgia and Mar-a-Lago and at the Supreme Court level, and about civil rights and women's rights and voting rights right here on Legal AF, midweek Wednesdays and Saturdays with Ben Meiselas and me. And if you want to support the show, you're already starting to do it in the best way possible. You're watching it. And you can also listen to us on audio podcast platforms of your choice, wherever you get them from. You go back and forth. It helps with the algorithms, helps keep the lights on, as we like to say. We got Legal AF After Darks, which are segments like we just did there, which we then post on our feed, on our YouTube feed, that you can, in bite-sized manner, you can, if you missed a segment or you missed an entire show, you don't have the ability to listen to an entire hour and a half, you have a little bite-sized version, or you can use that to help bring people along for the ride here and have them join our audience and our movement. Send them that clip and say, hey, here's that Legal AF I was talking about. Take a look at this 8 or 10 minute clip. And that's a great way to support the show. And then, of course, you can leave comments here. Thumbs up are great. We like those. Live chats like we're doing tonight. Amazing. We're usually top 2 or top 3 in the world. On a news show like this or any kind of show like this. That's another way to support us. Go back out and do comments in the comments section, permanent comments related to tonight's show. That's helpful too. And then if you want to fly the flag of Midas Touch and Legal AF, we got a merchandise store. You can get t-shirts, coffee mugs, all sorts of things at store.midastouch.com. But everything else I've talked about, free subscribe to the Midas Touch Network. That really helps. We're so close to 2 million free subscribers. I can't believe I'm saying those words. And things like Alina Habba using us in cross-examination can only help. Bring some other people over here. We got a big tent over here at Legal AF and the Midas Touch Network, so that helps. And you can do that for us. And eventually we'll have some other ways that you can get involved and with Legal AF. But we've reached the end of our midweek show. It's hard to believe we could just stay on the air. Literally, it's like the Jerry Lewis telethon. We could just stay on the air all day, 24/7, doing nothing else, just rotate out. That sounds like a great idea. Just rotate out people. It sounds like a network, a real network. We might do that one day and shock the world with it. Karen, last words for you, my esteemed colleague.
Last words. It's always hard to pick a topic or pick the topics because so much goes on, right? And we're always going back and forth. What about this? What about that? I agree with you. We could do this all day, every day. And There's just no shortage of information. I feel bad. There's a motion that Donald Trump submitted in the Mar-a-Lago case that we didn't get to. I'm going to do a hot take on that. There's just so much that you have to pick and choose because you can't keep up.
That's where the hot takes have come in handy.
Yeah.
And I think when people used to say do longer shows, what we interpret that as meaning do more real-time reporting and analysis on things that happen between the shows. We added Wednesday, that now famous day. There should be a bronze bust statue of you and me out in front of your old law firm's offices where we met, and that was the moment. The midweek was born, what
about me?
I still love that. I was thinking about this person. What about me? What about me? It's entirely correct. And we did that because there was just so much for Ben and me to do on Saturday that had already happened, and it started to get stale as we got there. In fact, Ben and I joke around about I used to do the lineups and then Ben did them, and I would be like because we only did once a week, so I try to cram in we once did. This might even be before Salty. Is there a time before Salty? I'm not even sure.
I don't think so.
Be like 12. And they be like, Popok, what? I'm like, we got to do these 12. This week was so, and we would do it. It'd be like a 2-hour show. But we used to have these discussions with the producers, like Brett did it in the beginning. And then it was Salty. He's like, we can't go beyond 2 hours because I can't upload it. Like, that's where we were.
What's our anniversary? When did we start?
4 years ago. 4 years ago, March. I don't know.
Not when you and I started. That's when you and Ben started.
When we founded Legal AF.
Yeah, we should figure out when you and I started, when the midweek.
I don't know, 6 months later? Something like
I'd love to know.
Salty, find out when the first episode with Karen was. We'll figure it out. We'll do a happy birthday.
Don't watch it, though. Oh, God, we've changed so much, right?
Happy birthday to us. But thanks for hanging on, even for the kibitzing here by the co-hosts. And shout out to the Midas Mighty and the Legal AFers. We'll see you Saturday. And then again, midweek, Wednesday, Karen and me.